All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning.
Good morning.
We are here for oral argument in our case number SA 22-0066, which is a consolidated case with petitioners William Cisar and Robert Marquoit, with real party and interest Betty Blanda. Just making sure. Yes. Okay. Betty Blanda. As you may know, we record and live stream these proceedings, so please give your name and the name of your client when it is your turn to present. You have a maximum of 25 minutes per side, although you are not required to use all of that time. We do require you to keep track of your own time. So there are clocks on the podium to reflect the remaining time that you have. Those are minutes, kept in minutes, including any amount of time you would like to reserve. Please keep in mind, we have read the briefing, we have studied the record, we have discussed the case in conference, so bear that in mind as you present. You may proceed, counsel.
Thank you, Your Honor. May it please the Court. I'm Brian Holohan. I represent Bill, it's pronounced Cisar, by the way, in 0066. We had the last word in writing, so I have only a few brief prepared remarks. And Mr. Callahan and I have agreed basically to split our time 50-50. When I'm done, I'm going to reserve the balance of my 50% for rebuttal. The first point I want to make that isn't in the briefing, we did in the introduction in the petition note that Mr. Cisar, Bill, had no contact with Mrs. Blanda once she moved to Arizona. We talked about the work that he did and how that wouldn't have been enough to establish specific jurisdiction, but the point that as I look back in the briefing I should have emphasized a bit more is he never had any contact with her. And the cases in which courts find that the forum state can exercise jurisdiction over the non-resident lawyer often, perhaps most of the time, turn on the fact the lawyer has some interaction with the client. And in this case, Bill had no contact with Mrs. Blanda once she moved to Arizona.
But he did work for her. You're saying he did work but just didn't have direct contact with her? Or?
Exactly. And that,
why is it important that he not have any direct contact with her if he's doing work on her behalf?
Because the cases in which out-of-state lawyers are found to be subject to personal jurisdiction, there's usually some interaction between the lawyer and the client who is a resident of the forum state. The lawyer reaches out to the client, the lawyer has interaction with the client.
Well, that would certainly be an important factor, but wouldn't it also be highly relevant if the lawyer is doing extensive work on their behalf? Why do you necessarily have to talk to the client to obtain jurisdiction?
Well, I don't mean to suggest that this is determinative. I'm just saying I didn't play this particular factor up as much as I perhaps should have. And the point is the fact that Bill had no purposeful direction at Arizona is reinforced by the fact that he never dealt with Mrs. Blanda. He did work on her behalf, but it was in Illinois, and it had nothing to do with Arizona, and he didn't have contact with her. That was the point I was perhaps poorly trying to make. The next point I want to make, in our petition at page 9, we noted that Mrs. Blanda argued, and this is a quote from our petition, the Superior Court had general jurisdiction over Bill based on his repeated solicitation of funds and legal work from Arizona residents. First of all, technically she made that argument in the district court because the briefing occurred in federal court. But more importantly, we didn't put a record cite for that. And the record cite is tab 5 of our appendix, page 62. I highlighted this because it's I think, characteristic of the Blanda's case. Mrs. Blanda says that Bill repeatedly solicited fund and legal work from Arizona residents. There isn't any evidence of that at all because it isn't true. He was involved in the super PAC that his maternal grandmother created, but he didn't solicit any monies from her, and he hasn't represented anybody in Arizona. He said that in a declaration. So it's just characteristic of the Blanda's case of overstatement. The next point I want to make is there is what could only charitably characterize as an awkwardly phrased sentence at page 14 of our petition. It made a lot of sense at the time it was submitted, but when I went back and read it, I realized it's really awkward. The sentence appears, it's the second to the last sentence on page 14. And we wrote in part, the Baker Court specifically rejected the claim that the lawyer's bar membership did not necessarily implicate substantial, continuous, or systematic conduct. And that's really awkwardly phrased. Here's what the court said, so you'll understand the point that we were trying to make. We agree with the Worthington and Cray courts that state bar membership does not necessarily implicate substantial, continuous, or systematic conduct. The final point of my prepared remarks I want to make is Mrs. Blanda referred to, quote, Bill's repeated and long-standing advertisement of his Arizona licensure in paragraph 1 of her statement of issues. Now, I don't know if putting that he was a member of the Arizona bar in his web profile or his LinkedIn profile constitutes repeated and long-standing advertisement, but it doesn't make any difference because the response is still so what.
Counsel, I want to talk to you a little bit about jurisdiction, general jurisdiction in particular. Would you say that over an individual, only a single state ever has general jurisdiction? Or can there be more than one at-home state for general jurisdiction purposes?
I acknowledge that it's conceivable, Judge, that a human being could have general jurisdiction over him or her in a state other than the state in which they reside. So, for example, my law firm used to have a Las Vegas office, and we had a lawyer who resided in Arizona, but who was in the Las Vegas office 4 days out of the week, week in, week out. Was there general jurisdiction over him in Nevada? Probably. But he went to Las Vegas 4 days a week, practiced law there, he had the Nevada bar membership, he had to, but he had physical presence, he had Nevada clients. He was rendering legal services in Nevada.
So can an individual be a resident of two states at the same time?
No. As I understand the rule, you're a resident of one state only.
So the general jurisdiction is a different issue. It's not necessarily coterminous with your residency. You can be subject to general jurisdiction and perhaps in more than one jurisdiction.
As I understand it, general jurisdiction is different from residency. You're subjected to jurisdiction in any state in which you are a resident. General jurisdiction is a substitute for residency. You have enough substantial and continuous conduct that the other state can be considered, the Supreme Court calls it your second home. Again, as I understand the cases, there's only one second home. I don't believe that persons or corporations can be subjected to more than one, but I'm not saying I'm 100% sure of that.
Did your client misstate the status of his residency when he averred that he was a statutory agent in 2019, or was he a resident of Arizona at that time?
Neither. He was an Illinois resident. he was unaware of the statutory requirement that a stat agent had to be an Arizona resident. And the form that he completed nowhere says, I'm a resident of Arizona.
Okay.
But you concede that the statute does require you to be a resident if you're an individual fulfilling that responsibility.
Yes, but this
Okay.
goes back to the point that I made in the petition, which is, having engaged in the general and specific jurisdiction analysis, the respondent judge necessarily and correctly found that Bill is not an Arizona resident. If Bill were an Arizona resident, the judge wouldn't have had to go through this analysis. That would have been the end of the game. I'm done with my prepared remarks, unless there are any more questions.
Thank you.
Thank you, Your Honor. May it please the court. My name is Charlie Callahan, and I represent Rob Moravka. And I jumped up assuming that you wanted to hear from both of us first before you heard from Weber. And I, too, am going to be very brief and reserve my time for rebuttal. I understand that it's convenient for Ms. Blanda to be here in Arizona because that's where she lives now. But personal jurisdiction is a constitutional issue with constitutional limitations. And when you apply those constitutional limitations here, it's not even a close question. There's nothing tying Mr. Moravka to this case. He's far more removed than Mr. Cisar is.
Well, let's focus on general jurisdiction because the Superior Court didn't find specific jurisdiction.
Correct.
And so general jurisdiction is not tied to whether or not he had a close contact with the case, but you'd have to admit that your client does have a fair amount of contact with the state of Arizona.
In what sense, Your Honor? Are you talking about the license? Well, let me focus on what the trial court, Commissioner Marquoit, focused on, and that is the practice of law. The first thing he relied on was that Mr. Moravka has a bar license here. And Ms. Blanda, in her response, said that we attempt to hide the fact that he's licensed in Arizona. That's not true. What we've said is that just having a license here, and all the cases agree with that, having a license here is not enough for general jurisdiction.
Is there an Arizona case on that?
Arizona has not addressed that point yet.
Okay.
But every other case has. And so what we have to do is what Commissioner Marquardt looked at was said, well, you have to be engaged in the practice of law in Arizona in order to be subject to general jurisdiction in Arizona, and I agree with that.
What about your client's contact in terms of his regular vacations, his golf course membership? Don't those suggest, some level of being at home in Arizona?
Well, I would disagree, Your Honor, and that goes to your point that you addressed to Mr. Holohan, and that is, can you have more than one home state? Because what the general jurisdiction analysis focuses on is the individual's domicile, and domicile is the intent to permanently remain and be physically present.
So we have some interesting characteristics of our state. One of them is we have many, many, many individuals who come and live here for a significant portion of the year, but not all of the year, our snowbird population. Isn't it possible that a snowbird should expect to have the court of their sort of second home have general jurisdiction over them?
I could see there is a district court case that this issue wasn't addressed by Ms. Blanda in the paper, so we didn't cite it, but I am aware of a district court case where there is some snowbirds from Canada who were subject to personal jurisdiction here in Arizona. But in that instance, the contacts that they used in order to establish the continuous, systematic, perpetual presence was, they had their own home here, utilities, vehicles.
Your client's wife has a home here?
She does now, yes. But he does not, and as he attested to in his declaration, he visits here occasionally.
But does it make that much of a difference if the house is owned by the spouse and you're here together all the time? Is that Would it
Well-
be the same as if you're just renting all the time? You're saying that's a distinction?
The distinction would be if they were living here all the time, but that's not the case here.
Well, let's say they were living here 5 months out of the year.
5 months out of the year, then you go back to the intent to permanently remain and be physically present. If you have systematic and continuous contacts here 5 to 6 months out of the year, then maybe you get there. Here, there's no evidence of that. All there's evidence of is coming to Arizona occasionally during the winter months to play golf, maybe over the weekend, and then leave again to go back home to Illinois. And that's the...
So I take this, am I correct in reading your answer as it is possible in a hypothetical case for two different jurisdictions to exercise general personal jurisdiction over the same individual, which would suggest that that individual could have two different domiciles?
I think it's possible. I think that the Arizona District Court recognized that. But again, you have to establish basically two homes. It's not, we're going to visit and spend some time here during the winter months and get out of the cold, but then go back home. And then come back again, to maybe get out of the cold, but then go back home. That's the key analysis, and there's no evidence here that he did anything other than visit occasionally.
Well, let's say you don't own homes in either state. Are you just in Arizona and I'm just leaving to get out of the heat for 6 months? Or I'm in Minnesota or Illinois and I'm leaving to get out of the cold for 6 months? Which is the state that can exercise general jurisdiction, or can both? You're just renting a place in both states.
Renting a place in both states, well, then the analysis, well, then property ownership is one indicia. And Mr. Marquoit doesn't own property here. His wife does. Maybe his wife is subject to general jurisdiction, but she's not part of the suit. That's one indicia. Then the second analysis goes to the intent to permanently remain and be physically present. Where's the evidence of that? Ms. Weber in her briefing cited 7 instances of golf over, a 7-month time frame before Ms. Blanda moved to Arizona. And I think that's key, because we have to talk about physical presence at the time we're trying to exercise jurisdiction. And the instances, there's only 3 instances that they discuss that has any relationship to Arizona from the time Ms. Blanda moved here until the time he was served. A 3-year period from November of 2018 when she moved here, and 2021 when he was named as a party. 3 instances. 1, prepared the taxes for the Blanda Foundation, which is an Illinois entity located in Illinois, and submitted the taxes to the Illinois Attorney General. That doesn't have any relation to Arizona. The second is Mr. Marquoit wrote a check as trustee for the Freeman Foundation, an Illinois entity, domiciled in Illinois, formed in Illinois, wrote a check on a bank account from Arizona as trustee of the Freeman Foundation to the University of Illinois. That doesn't have any connection to, that's one instance. And held the bar license. And again, you have to look at those singular instances. Does that has to be put next to the due process requirement of systematic and continuous contact. You can't have those instances to comply with due process. Those instances have to they have to fit within the framework of being being systematic and continuous, and that it just doesn't exist here. All right, with that, I will reserve the rest of my time for rebuttal. Thank you.
Thank you, Counsel. Counsel?
Thank you. Good morning. May it please the court, Lindsay Weber of the Burgess Law Group, appearing on behalf of plaintiff and probate petitioner Leslie Blanda in her capacity as authorized attorney-in-fact for Betty Blanda. Your Honors, it's undisputed that Arizona applies a liberal approach for the exercise of personal jurisdiction. It's also undisputed that the facts and circumstances surrounding personal jurisdiction are to be viewed not in isolation, but in the totality. And lastly, the probate court's exercise of personal jurisdiction is appropriate under either a specific jurisdiction analysis, a general jurisdiction analysis, or both. Here, plaintiff asserts the probate court's exercise of jurisdiction over Bill Cisar was appropriate under both a general jurisdiction and a specific jurisdiction analysis. Petitioner further asserts that the probate court's exercise of personal jurisdiction over Robert Marofka was appropriate, and while the probate court did not reach the issue of specific jurisdiction with regard to Rob, the facts and circumstances demonstrate that both general and specific jurisdiction exists over Rob as well. And per Arizona law, it does not matter whether a defendant is physically present in the state, but rather the inquiry is whether the conduct and contacts with the forum state.
Could you go right to Mr. Cisar? Why don't we start with Mr. Cisar and just explain what you think are the strongest evidence showing? Why don't you start with general jurisdiction?
Certainly, Your Honor. In its ruling dated February 8th, 2022, the probate court found that it possessed both specific and general jurisdiction over Bill. The trial court ruled that it had general jurisdiction over Bill, listing 4 primary areas of contacts with the state of Arizona that were substantial, continuous, and systematic. With respect to Bill, the following facts are or should be undisputed based on the record. First, that Bill is an Arizona licensed attorney since 2013 who graduated from Arizona Law School and continues to maintain actively his Arizona law license.
Counsel, I've done a lot of research on these cases, and I am not aware of any cases that make that really a determinative factor. So what's your best case for that proposition?
Your Honor, isolated or alone, I would agree that the case law does not indicate that solely having a law license would subject you to jurisdiction. But here there are many other contacts. And in fact, the specific jurisdiction...
You're saying if someone is licensed in 5 different states, but is only practicing in 1 state, 5 other states could assert general jurisdiction?
I am not necessarily saying that, Your Honor, no.
But you're saying, so what are the specific things that Mr. Cisar did in Arizona?
Certainly, Your Honor. The public records and Bill's own petition at page 12, second paragraph, confirms that Bill has previously accepted and served as a statutory agent for at least 2 Arizona entities, and that he continues to serve as a statutory agent for at least 1 entity, which according to his own filings remains active. And per Bill's declaration, he is in fact the lawyer, utilizing his Arizona law license, who formed one of those entities under Arizona law in 2019 and secured its rights as a tax-exempt Arizona entity. You'll find that in the Bill appendix at 54, paragraph 5. That is a substantial contact with the state of Arizona and also ties to Bill's practice of law under his Arizona law license. According to Bill's own declaration, he resided in Arizona at least through some point in 2012. And finally, Bill...
You're saying residence through 2012. Why is that relevant to the analysis at all? We're well down the road from 2012.
Understood, Your Honor. During that time, he also received his law degree from an Arizona law school and then became licensed in this state, which status has continued forward from that point.
But what's the point that we're looking at? It's the point that's relevant here is when the court is attempting to assert its jurisdiction, correct?
Understood, Your Honor. That was a historical fact.
And that would be in June of 2021, correct? That's when Mr. Cisar and Mr. Marofka get brought into this lawsuit.
The amended petition, correct, was filed in June of 2021.
Okay, so the court is trying to take jurisdiction over these individuals in June of 2021. And this kind of piggybacks off of Judge Catani's question, which is, why is it relevant? Back up. If we assume that individuals in the United States can remain mobile and can change their home state, why is it relevant to us what they do in 2012 when 2021, June of 2021 is the relevant timeframe?
It showed long-standing and continuous contacts with Arizona that stretched back many years, and some of those contacts continued forward through the times alleged in the petition, which are relevant as well to specific jurisdiction, and beyond that time, as it relates to the conduct that he directed at Betty after she relocated to Arizona in late fall 2018. So again, understanding we're looking at the totality of the contacts, not just an isolated...
What's the specific conduct directed at Betty after she moved to Arizona?
Certainly, Your Honor. For example, Bill's and Rob's work performed throughout late 2018 and through at least May or June 2019 relating to the Blanda Foundation, which was performed concurrently with and after Betty was relocated to Arizona.
Wasn't that work tied to proceedings in Illinois? It seemed like a lot of it was taking care of matters for her in Illinois.
I believe the allegations are that the work was performed in Illinois, but the ultimate funding source and the human behind the Blanda Foundation is Betty Blanda.
But if Betty Blanda starts a trust in Illinois and moves to Arizona and is just continuing, I'm asking you to file my Illinois tax returns, does that confer general jurisdiction over the lawyers who are arranging to have tax returns filed in Illinois?
Perhaps not as relevant to the general jurisdiction analysis as it is to the specific jurisdiction analysis, Your Honor.
Well, could you give us, I guess I'd like to know, what's your best set of facts that show that there's general jurisdiction over either of the attorneys?
For Bill, those would be the primary areas relied on by the trial court: his membership, his practice of law, his involvement with other Arizona entities and residents, and as well his continued contacts and work performed and billed to Betty Blanda. With regard to Rob, again, it's his membership and law license here, his significant time spent here over the course of each year, in some instances every week, his ownership of the Cisar and Marquoit law firm, which holds itself out to the public as having a Phoenix, Arizona office
but
and a
you're
presence.
saying an unrelated, someone entirely unrelated to this litigation, just an Arizona resident, or let's say an Arizona resident can just assume jurisdiction. She slips and falls in Illinois. Can she sue that person in Arizona based on those contacts when everything happened in Illinois, but she's an Arizona resident? Is there general jurisdiction over the defendant who created a hazardous condition in Illinois? Is there general jurisdiction based on someone having a law license in Arizona, who, with the context that we have here? If that were the case, would you assert that there's general jurisdiction over the lawyer?
Over a slip and fall?
A slip and fall in the lawyer's office in Illinois. But it's an Arizona resident who can certainly file lawsuits in Arizona, but can you assert general jurisdiction over someone? You slip in their law office in Illinois, but they have an office in Arizona and they're licensed to practice in Arizona. Does that confer general jurisdiction over that lawyer?
If those are the only facts, then not necessarily. But here we have many more facts that tie Mr. Marquoit both to the state of Arizona in a general sense, and also tie him very closely to Betty Blanda and the Blanda Foundation. And here's the relevance of the Blanda Foundation. I do not argue that it is an Arizona foundation. It was organized in Illinois. But the funding source is Mrs. Blanda. And the reason the foundation is so integral to the scheme and the fraud committed against Mrs. Blanda is that is where the respondents directed the residuary estate and the Blanda assets and funds to flow to. And so when they took action in order to perpetuate that scheme throughout the end of 2018...
What are the actions that perpetuate the fraud?
Your Honor, keeping the Blanda Foundation active as a tax-exempt entity, submitting tax returns, and trying to maintain its status so that if in the event that Mrs. Blanda unfortunately passed, her residuary estate would in fact flow into the Blanda Foundation and into the hands of these respondents. They placed themselves as members on the board. They maintained that every time they filed an annual report after Mrs. Blanda was relocated to Arizona. They submit letters and tax returns on behalf of the Blanda Foundation to perpetuate perpetuate that artifice and scheme to keep that as the repository for the Blanda residuary estate. Those are actions absolutely directed at Betty Blanda as an after.
When did the fraud occur at the creation of the trust in Illinois? Is that what you're saying? That was the initial fraudulent conduct?
The fraud continued throughout the lifetime of the Blanda Foundation.
At the creation?
Well, unfortunately, the Blanda Foundation work was not done correctly, and so for many years it vacillated between whether it had tax-exempt status or not. And so, to be honest, it's difficult to pin down. I believe they finally obtained tax-exempt status in 2018.
Before Ms. Blanda moved to Arizona?
I believe so, Your Honor. I believe it was early 2018, and then Bill Cisar in October of 2018 sent correspondence regarding the Blanda Foundation again to the state of Illinois, and again in May and June 2019, 6 months after Mrs. Blanda was relocated here, continued submitting documents and charging Mrs. Blanda for work pertaining to the Blanda Foundation. The respondents have argued that those charges weren't billed, but that's just incorrect.
But what about the conduct was fraudulent that you're saying occurred? Something was already created in Illinois, and you're saying just merely the fact that it continues, no matter where Ms. Blanda moves, as long as they continue to operate the trust, they're going to be subject to general jurisdiction in whatever state, wherever she moves?
Well, Your Honor, this is not a circumstance where Betty just up and moved to Arizona without any indication. In fact, the Cisars themselves orchestrated her move to Arizona, and Rob and Bill had a part of that. It's not at all unforeseeable that their conduct after November 2018 was directed at an Arizona resident, because they made sure of that. For example, apologies, Your Honor. The time records of Cisar and Moravka in the record in this case show a concerted strategy by all of the respondents, starting with the time entries just days after Betty's fall and head injury, that discuss strategizing, quote, selling Betty on Arizona, end quote. You'll find that in the appendix at 115 to 117. And among other things, the September 11th, 2018
How is selling Betty on Arizona some kind of fraudulent conduct?
As part of that, they also allegedly had Betty execute an expansive power of attorney that was expressly, quote, intended to give Mr. Cisar additional agent authority for Betty's contemplated move to Arizona. You'll find that in the second supplemental appendix at 414. They were well aware that they were getting ready to ship Betty to Arizona to put her in an assisted living facility just miles from the addresses that had been used by Bill Cisar and Robert Moravka when representing their presence in Arizona on behalf of Cisar and Moravka, and independently in their roles with various Arizona entities, including the Wilkinson Foundation for Bill and the Freeman Super PAC for Rob. 1 week after they cemented that authority through the power of attorney, Bill undertook a project and billed Mrs. Blanda for, quote, discussing with Tom Cisar distributions pursuant to Blanda Trust's and estate plan. You'll see that in the appendix at 117. Again, perpetuating the repository and the residuary estate flowing into the Blanda Foundation.
This is after she's moved or before she's
This is in the moving process, Your Honor. That time entry was September 2018, as she's in the rehabilitation facility in Illinois.
So she's still in Illinois. Okay.
But contemplating and planning that move to Arizona. A few weeks later, perhaps concerned about the influence being exerted by his mother, father, and law partners, Bill charged Betty for 2.5 hours at the rate of $500 an hour for, quote, research on issues related to undue influence. You'll see that in the appendix at 119. And then 8 months after Betty relocated to Arizona, Bill again charged her for, quote, meeting with accountant to discuss future of Blanda Foundation, a foundation that by this point his father, and Rob had taken over as board members. You'll find that in the appendix at 127. In fact, Bill is the attorney who originally drafted the foundation bylaws and the amended bylaws that removed the Blanda family members and instead replaced them with Bill and Rob. You'll find that in the appendix at 83. Then contemporaneous with Betty's move to Arizona, Bill filed the annual Blanda Foundation report that named him, Tom, and Rob as the foundation officers and board members. You'll see that again in the appendix at 87. And again in May 2019, 6 months after Betty had relocated to Arizona, Bill again, quote, reviewed and filed Blanda Foundation, Illinois, and federal tax returns, and further submitted the Illinois Annual Charitable Organization Report. You'll find that at the Appendix 87, and then Bill's letters located at App 139 and 140, again listing a Phoenix, Arizona office on the letterhead for Cisar and Marquoit on correspondence relating to the Blanda matters. All of these actions were intended and designed to ensure that Bill, Tom, and Rob were in control of the residuary estate of the Blanda family, which they had orchestrated to flow into the Blanda Foundation. And a significant portion of these activities were undertaken by Bill and Rob after Betty was relocated to Arizona. It's unreasonable to believe that Mrs. Blanda just up and unilaterally moved to Arizona. The evidence and the uncontroverted allegations of the petition demonstrate that Mrs. Blanda was coerced into moving to Arizona by the Cisars, who paid themselves handsomely for those efforts and tucked her away in an assisted living facility just miles away from the other Arizona addresses utilized by Rob and Bill. A couple points regarding Bill's reply, Your Honors. The third footnote in the reply on page 4 asserts that Bill's late 2018 and 2019 time and work performed for Mrs. Blanda was not billed or paid. That's just false on numerous levels. First, the record shows that C&M did issue numerous bills for the Blanda matter after Mrs. Blanda was relocated to Arizona, and that Tom Cisar paid those bills from Blanda funds that he had moved under his control. You'll see those invoices in the second supplemental appendix at 443 to 461.
Is there a claim that's alleged that Ms. Blanda was fraudulently induced to move to Arizona?
That is not an express claim in the action, Your Honor, although those actions may fall under the vulnerable adult claims, the 46-454 claims.
That can be pursued and that establish general jurisdiction over the lawyers for fraudulently inducing someone to move to Arizona?
The inducement argument is in response to the unilateral choice argument that is raised and throughout Bill Cisar's pleadings, that they had no way to, and actually Mr. Marquoit also is on that when he talks about it was unforeseeable. It was unforeseeable that the harms arising from their action would affect an Arizona resident, and that just isn't the case. They helped with the move. They set up the instrumentalities, the powers of attorney, so that after the move was effectuated, they would remain in control of the Blanda assets and funds.
Sounds like more of an argument, though, with having to do with what they did after she was in Arizona. I'm not understanding the fraud in inducing someone to move to Arizona. If she moves here or not, or she moves somewhere else. People move all the time for whatever reason. And the specific actions that perpetuated the fraud, you're saying just filed tax returns for her in Illinois?
They continued the existence of the Blanda Foundation and continued the tax-exempt status in order to allow the Blanda assets to flow into that. They further paid themselves handsomely for that work. After Mrs. Blanda was relocated to Arizona, Tom Cisar issued a check to the firm of...
Did Mrs. Blanda or somebody else with authority attempt to dissolve the foundation and they maintained it nonetheless? Or is there some allegation that they acted contrary to direction from a client?
There is nothing in the record that shows that Mrs. Blanda was aware of the Blanda Foundation. Filings are made by Tom or Bill or Rob. The signatures on the tax returns and the other materials, according to the forgery expert in the case, are not Mrs. Blanda's. So it was not necessarily on Mrs. Blanda's radar, along with a lot of other actions taken by the Cisar and Marquoit attorneys that, due to concealment, changing addresses, dropping Blanda family members off the board, etc., resulted in her really being kept in the dark. Keeping in mind,
she had family members on the board of a foundation, but she was unaware of the foundation?
Your Honor, the family members were also unaware that they had been listed in the original filings that were ultimately not correctly done in Illinois. There is much in this case, including almost $1.7 million of attorney's fees taken from the Blanda assets that were done under the table or without Mrs. Blanda's knowledge or awareness. At the time of the move, she was a 94-year-old widow. She trusted the lawyers at Cisar and Marquoit, and as a result, substantial sums of money flew out the door, including $166,000.
This is while she's in Illinois.
No, Your Honor, the $166,942 was paid on January 7th, 2019, after she was in Arizona. And it was paid the same day that Tom Cisar pressed print on an invoice and then took a checkbook and wrote $166,000.
Was this for work done, though, before she moved to Arizona?
It flowed over both time periods, Your Honor. It was up through, I believe, according to their filings, December 21st, 2018. So a portion of the time paid on January 7th was pre-move, the lead up to the move, and some portion of it was after the move.
Is
That
it
bill-
not conceivable that a lawyer can have a relationship with a client, and then the client moves and continues, and the lawyer continues a project that began before? The argument isn't that there's general jurisdiction, that confers general jurisdiction over the lawyer, the fact that the client moved midstream while the lawyer finished up a project in the lawyer's home state.
Your Honor, again, Bill and Rob chose, it was their choice to continue performing work for and charging Betty Blanda and the Blanda entities after she relocated to Arizona. I've already addressed as well their involvement in the lead up to her moving. They had meetings regarding the power of attorney. They had meetings regarding her Arizona real estate. They had meetings regarding what to do with the Blanda estate and the residuary estate in that time period. But after she was relocated to Arizona in November 2018, they continued working and continued billing Betty without ever suggesting perhaps that she seek new counsel. Because most likely, because Bill, Tom, and Rob were licensed in Arizona, because Cisar and
Were they
Marquoit
filing something in Arizona? Why did they need an Arizona license in their dealings with Mrs. Blanda?
they did not need one. My point was once she was here in Arizona, Your Honors, there was no need to obtain replacement
But
counsel.
that goes to Judge Faria's question. If the client leaves and you continue to do work, how does that establish general jurisdiction? The fact that you're also licensed in another state, if you're not using that license for any of the work that you're doing for the client, and it just relates to the work that was being done in Illinois.
I think the continued work is more aimed toward the specific jurisdiction arguments, Your Honor, that they chose to continue working for Mrs. Blanda, billing her at exorbitant rates for unapproved amounts and paying themselves out of the Blanda assets. And those were choices they made after Betty had relocated to Arizona. They could have suggested alternate counsel. They could have suggested all sorts of things, but they didn't. Instead, they continued taking Blanda money and performing services, which we've heard from both counsel, without ever consulting Betty. They appear to think it is a plus that they were continuing to work on behalf of Betty's entities and her personal matters without ever talking to her or reaching out to her. And that alone is another basis for cause for concern on their continued interactions. And
But that goes to there was a power of attorney then, apparently it was signed in Illinois, right?
There was a power of attorney signed on September 11th, 2018, Your Honor, yes, drafted by Rob and witnessed by Rob in the rehabilitation
But is there a
facility.
suggestion that it was improper to obtain that?
I think it is a step in the chain of the fraud against Mrs. Blanda that they continued to gather more power from her, especially during a time when she was in a potentially recovery state. You'll note in the record that Mr. Marquoit took it upon himself to write a memo that he, as a lawyer, found her to be competent at the time. But those are services, again, in contemplation of Betty's relocation to Arizona. Just very quickly, Your Honors, in terms of the law at issue, and I think everybody has acknowledged there may not be a ton of law on the issue, but I do think the Scott v. Kemp decision, a fairly recent 2020 decision from this court, is instructive. And we would ask that this court consider the standards set forth in that decision and reach the same result here, namely affirming the trial court's denial of the motions to dismiss. In addition, as noted in the trial court's rulings, and I believe undisputed under Arizona law, there's a reasonableness standard here. And there's nothing unreasonable about having licensed Arizona attorneys who have represented numerous Arizona residents and entities and have substantial and systematic contacts with this
You're saying
state.
numerous Arizona residents? How many are you saying?
Mrs. Winifred Freeman through the Freeman Super PAC and Betty Blanda, as far as we know.
That's two, that's the numerous.
Yes, as far as we know, Your Honor. And please do keep in mind that if and to the extent that this court has any doubt that either general or specific jurisdiction exists over these respondents in the probate proceeding, that we would ask for a remand so that evidentiary proceedings can take place. We have not taken jurisdictional discovery. What is before this court is just based on the record in this case thus far, without any directed discovery at jurisdictional issues. So with that, Your Honors, for all the reasons set forth in the filings before the probate court and this court, and supported by the totality, not just isolated events, we would respectfully request that the court affirm the trial court's ruling. Thank you, Your Honors.
Thank you, counsel. Mr. Callahan.
Thank you, Your Honor. Mr. Holohan wanted me to go first. And I just wanted to briefly touch on a couple of things. Ms. Weber, in her argument, continually tries to lump Mr. Moravka and Mr. Cisar together, talking about they did this and they continued to do this after she moved to Arizona. Absolutely not. There is zero evidence that Mr. Moravka did anything after Ms. Blanda moved to Arizona. The billing entries that are...
Counsel, what of Ms. Weber's argument that there should be jurisdictional discovery in order to develop those types of things? I mean, well, we have a scant record here, so...
Right, and if that was an issue, that should have been raised in the probate court. She chose to not ask for any jurisdictional discovery. She chose to file her response and argue on the merits, or argue, I have enough here to establish jurisdiction. If she's mistaken, which she plainly is, I don't think the remedy is to remand for additional discovery, but I guess that is a possibility. You can remand for further proceedings consistent with your opinion, and if the probate court decides to allow jurisdictional discovery, I guess that would be within the court's discretion. But at this point, without moving or requesting additional discovery before responding, I don't see that as a viable issue. But
so you're arguing that Ms. Blanda waived it?
Yeah, I would say that she waived it, or in the alternative, remand for proceedings consistent with your decision on jurisdiction, and let the probate court address it.
Thank you.
But
Counsel,
again, going back...
If I could just ask you really quick, as Mr. Moravka's counsel, the court, while it reached the specific jurisdiction question with respect to Mr. Cisar, did not reach that question with respect to your client. If we agreed with you that there was no general jurisdiction, are we able to reach the specific jurisdiction question, or would that have to be remanded?
Oh, no, you can absolutely, because specific jurisdiction requires conduct directed at Arizona that gives rise to the cause of action. And in this instance, you look at the billing entries at Appendix 232.
So in other words, you're saying that we have the record in front of us to make that determination?
Yes, there was. Mr. Moravka did nothing. There's no billing entries. There's no evidence he did anything after Ms. Blanda moved to Arizona. The last time entry is September of 2018, 2 months before she moved here, where he prepared his memo attesting to her competency with respect to the power of attorney, assigning Tom Cisar as her power of attorney. That's the last he had anything to do with Blanda, other than filing the Blanda Foundation taxes in Illinois. And I wanted to specifically bring up that point because Ms. Weber was asked a question about that, whether that's enough for general jurisdiction, and I tried getting the exact quote as possible. Filing taxes for Blanda Foundation is not necessarily, or particularly, I can't remember which word she used, relevant to general jurisdiction, but it's relevant to specific jurisdiction. But general jurisdiction, the filing of the taxes is what Commissioner Marquoit, that was the linchpin for his decision, is those taxes establish general jurisdiction. And they don't, according to Ms. Weber. And they don't establish specific jurisdiction because they're not directed at Arizona. The Blanda Foundation is an Illinois entity. It was formed in 2012 in Illinois. It continued in Illinois, and it's still in Illinois. And this notion that, well, that was fraudulently formed and it was fraudulently perpetuated, that sounds like a great, for 7 years or 6 years before Ms. Blanda moved to Arizona, that sounds like a particular issue for the Illinois courts, not for Arizona, and certainly not against Mr. Marofka.
What if the allegation is that Ms. Blanda became unaware of anything that was happening after she moved to Arizona, and what was filed on her behalf was essentially a fraud on a vulnerable adult in Arizona?
Well, there is no evidence that anything was filed on her behalf other than the Blanda Foundation taxes. And again, the Blanda Foundation is an Illinois entity, and those taxes were filed in Illinois with the Illinois Attorney General. That's where the conduct occurred. And if there are any other questions, I will let Mr. Holahan have the last minute 45.
I couldn't possibly begin to address all of the mud that Ms. Weber slung in the 25 minutes she was up here in a minute 40, so I'm going to address a few of them. I want to address the suggestion that remand is appropriate. She didn't ask for a discovery in the trial court. She didn't ask for a remand in her brief. Under ordinary appellate principles, that would be waiver, but this is a special action. You're being asked to enter an order directed to the judge to dismiss the case. I don't think remand would be appropriate under those circumstances. 2, if you examine the printout of time, all of this before Betty moved to Arizona sinister behavior that she keeps citing was conduct committed in Arizona, and if you look at the 2 or 3 entries for Bill, it has nothing to do.
You mean Illinois, right?
That's what I meant to say. Did I say something else?
You said Arizona.
I beg your pardon. I meant Illinois. I was just testing y'all. And if you look at the actual things Bill did, they had nothing to do with her move to Arizona. She wants to suggest that they do, but they don't, right on their face. 3rd, I don't know how many times I can say that Mrs. Blanda was never billed for any time in 2019. There was one last round of bills that are in the end of 2018. They were paid in 2019, but there was never a bill after that. And if you look at what's in the record, what the plaintiffs put in their response, it is a printout of billed and unbilled time. It is not a bill itself. And the way you can tell that is it's not on the law firm stationery.
I know your time's up, but I have a question. Regardless whether a bill is sent out, was work performed, if the allegation is the work that's being done is perpetuating a fraud after she's in Arizona, and regardless whether a bill is sent out for that, is there an allegation that some work was done that somehow perpetuated a fraud after she was in Arizona?
I have to confess I'm not entirely clear what it is they're claiming, but even if I concede that point, for jurisdiction, it was done in Illinois.
But if you target, you know that there's a vulnerable adult in Arizona, would that not be? Would you say would that go to specific jurisdiction? Maybe not.
I don't think that would be enough for specific jurisdiction. Remember, the case is dealing with out-of-state lawyers. There has to be purposeful conduct addressed to the state. She lives there, but it isn't addressed at her. It's work being done in Illinois.
And again, if I know there's a vulnerable adult or vulnerable person in Arizona, and I'm going to do some work knowing that person won't understand what's happening, isn't that an arguable basis for jurisdiction?
No, not if, obviously I'm not conceding there was any fraud, but if this supposed fraud began in Illinois and was continually perpetuated in Illinois, and she moved to Arizona for whatever reason, that's not purposeful availment at Arizona. Unless there are other questions, I guess I'm done.
Thank you, counsel. We thank you for your arguments. We will take this matter under advisement and issue our decision in due course, and the court stands adjourned.